Welcome to CRIM Law, Episode 1 of the Zech Support Legal Studies series. Today, we're breaking down the basics of what a crime is, how the justice system categorizes offenses, and what happens once someone is charged. We will be covering the legal definition of crime, types of offenses, be it felonies, misdemeanors, infractions, wobblers, limits on laws and punishments, the role of prosecutors and defense attorneys, how criminal cases move through the system, and the importance of the jury trial and reasonable doubt. Let's get started. What is a crime? Under California Penal Code Section 15, a crime is an act committed or omitted in violation of a law forbidding or commanding it. That means you can break the law by doing something illegal, like stealing, or by failing to do something required, like not paying taxes. Now, when you break the law, there are consequences. Punishments can include fines or monetary penalties, imprisonment, time in county jail or state prison, removal from office. Public officials can lose their positions. Disqualification from public office. You can be banned from holding government jobs. Death penalty, reserved for the most severe crimes like capital murder. Let's now break down why we have criminal laws and how we classify crimes. Criminal laws exist to protect society. They do this by punishing offenders in different ways. There are 5 main justifications for punishment. Number 1, rehabilitation, reforming offenders so they don't re-offend. Example, a drug offender may be required to complete rehab instead of jail. Number 2, deterrence, preventing future crimes. Example, harsh DUI penalties discourage people from driving drunk. Number 3, incapacitation, removing criminals from society. Example, a serial offender sentenced to life in prison. Number 4, retribution, the idea that criminals should pay for their crimes. Example, a convicted murderer receiving a life sentence. Number 5, vengeance, society's emotional need for justice. Example, public outrage leading to harsher sentencing laws. Now, not all crimes are treated the same way. Let's break down how the law categorizes different offenses. The law recognizes 4 major categories of crimes. Number 1, felonies, the most serious crimes, the punishment of which could range from over 1 year in a state prison all the way to death. Examples of felonies and their penal codes: murder, Penal Code 187, rape, Penal Code 261, robbery, Penal Code 211, arson, Penal Code 451. Number 2, misdemeanors, less serious offenses, punishable by up to 1 year in county jail and fines. Examples, DUI, Penal Code 23152, petty theft, Penal Code 484, and simple assault, Penal Code 240. Number 3, infractions, minor violations punishable by fines only, no jail time. Examples, speeding, jaywalking, littering. Number 4 falls into 2 subcategories, wobblers and wobblettes. Wobblers can be charged as either felonies or misdemeanors depending on circumstances. Example, domestic violence, Penal Code 273.5. Wobblettes can be either misdemeanors or infractions. Example, driving without a license, Penal Code 12500. Now that we understand different types of crimes, let's look at legal limits on defining and punishing crimes. Limits on laws and punishments. The Constitution prevents the government from making unruly laws. Here are some things that they cannot do. No bill of attainder. The government cannot pass a law that punishes a specific person or group without a trial. No ex post facto laws. You cannot be punished for something that was legal when you did it. No cruel and unusual punishment. The Eighth Amendment prohibits excessive punishments. Equal protection clause. Laws must be applied fairly to everyone. Here is a real-life example from 1873. California had a vagrancy law that made it a crime to be homeless unless you are a California Indian. That law clearly violated equal protection and was later repealed. Let us now discuss prosecutors and defense attorneys and their roles in the justice system. Prosecutors represent the people and decide what charges to file. Defense attorneys protect the accused and ensure that they receive a fair trial. It would be wise to note that prosecutors have something called prosecutorial discretion, which can sometimes be misused. Vindictive prosecution, or increasing charges as revenge. Example, a defendant appeals a conviction, wins a trial, and suddenly faces more charges. Discriminatory prosecution, charging people based on race, gender, or religion. Overcharging, stacking charges to pressure plea deals. Now let's go through the step-by-step process of a criminal case. Step 1. In the criminal case process, arraignment. The defendant hears the charges and enters a plea. Step 2. Preliminary hearing. The judge determines if there's enough evidence for a trial. Step 3. Grand jury indictment. In some cases, a secret jury decides whether charges should move forward. Step 4. Plea bargaining. It should be noted that over 90% of cases end in plea deals. Step 5. Trial. If no plea deal is reached, the case goes to a jury. Jury trials and reasonable doubt. The Sixth Amendment guarantees a jury trial, but jurors cannot convict unless the prosecution meets the burden of proof. Beyond a reasonable doubt, this is the highest standard in the legal system. The jury must be morally certain of the defendant's guilt. Here's a famous case as an example. Brady v. Maryland, 1963. This case ruled that prosecutors must turn over evidence that helps the defense. If they don't, the conviction can be overturned. The criminal justice system is complex, and every decision from charging a suspect to sentencing shapes the way justice is served. That's all for today's episode. If you found this helpful, please be sure to subscribe and tune in next time as we break down the next chapter in criminal law. Until then, stay informed, stay curious, and stay out of trouble. And always remember, when you need help, you can always call Zech Support.